Hello, everyone. They'll follow a very brief lecture on the rule of law in the United Kingdom, with particular reference to England and Wales, but that's over 90% of the population of the UK, so the distinction is perhaps a little academic. Anyhow, so you might read The Rule of Law by the late Lord Bingham, of happy and glorious memory, and he said the trouble is everybody says they're in favour of it, and it means little more than the hurrah for our side. So it's worth asking ourselves what the rule of law is. And Albert Venn Dicey, Vinerian Professor of Public Law in the University of Oxford in the late 19th century up until about 1922 when he died, he's the one who invented this expression, rule of law. Now, the English, they like to claim this as their own invention, as they do on many things, and sometimes they're right, but people have traced the rule of law back to ancient Babylonia, India, and so forth. But let's look at it in a British context. Dicey, he said that the rule of law is not dicey, like himself, nominative determinism perhaps, but he said that there were two pillars. There was the rule of law and parliamentary sovereignty. But the tricky thing is, do they support each other, or perhaps they're clashing with each other? Because we know that the government makes the law, particularly through Parliament, and obviously there are governing parties there and opposition parties there as well. But they're also bound by the law. Therefore, they could make a law that was amenable to themselves, which would allow them to do things which they weren't previously allowed to do, as in they've been illegal. So this whole concept of rule of law and parliamentary sovereignty, perhaps parliamentary sovereignty makes a mockery of the rule of law, since they could allow themselves to do things which were illegal up until this point. We know the law is dynamic; it's never static, and it's malleable. It moves with the times. Sometimes it doesn't move as fast as it should do. That's one of the things that was an eye-opener to me when I began to study law, is that the very word law suggests to me certainty, predictability, and all the rest of it. But if you delve into it, you shall find that often it's much more nebulous than that. Quite often we can only say probably, possibly. These things are quite debatable. So one of the key observations that A.V. Dicey makes is that the law must punish people. It's not up to an individual. The law is impersonal. The United Kingdom is a Rechtsstaat. So that's why when someone's charged with a criminal offence, it's R and whoever it is, or we often say the Crown, R standing for Rex or Regina, as in Latin for king or queen. And it's actually not obviously the king or queen as an individual, but as a constitutional abstraction to be a living symbol of the state. So if someone is a victim of a crime, it's not up to that individual whether to press charges or not. I hear that this happens in the United States occasionally. So the law is impersonal. That might seem a little bit inhuman. There are aspects where the law is sometimes a bit personal, takes into account individual circumstances, and it ought to be free from the whimsical nature of human affairs, whereas I don't feel like doing this, or I quite like you, or I dislike you, so I'm going to come down hard on you. The trouble is, the law has to be administered by human beings and not by robots, and people have prejudices and emotions, and therefore they are imperfect. So the rule of law, as we'll discover, is an idyll towards which one strives, an idyll which might never be attained, but aim for the sky and you'll hit the ceiling. So I can't remember who said it, but be you ever so high, the law is always above you. Anyway, there was the celebrated case of M and Home Office. Incidentally, you would read MV Home Office, but the V is pronounced and in the Commonwealth. I know that V stands for versus, which is the Latin word for against, but in Commonwealth countries you say M and Home Office, or you could say M against Home Office. Now, in the United States, they would say MV Home Office if they're to see this, or possibly M versus Home Office. Now, why don't we simply do it the American way, which is far more logical? And I slip up and catch myself doing the American way sometimes. American way is straightforward. What you see is what you get. Anyhow, in this leading case, someone who was in the United Kingdom illegally was deported by order of the Home Secretary. So he or she is in charge of such matters, and the person was not granted a court hearing in which the applicant could plead his case, saying that he ought to be allowed to remain within the United Kingdom. Anyway, the courts discovered this, and they ordered this person to be brought back from overseas in order to be granted his right as a court hearing. So the Home Secretary was hauled over the coals, was specifically scolded for this because he had been negligent in his duty, and a person who was in the UK illegally still had a certain legal right to his day in court to plead his case, might win, might lose, but he must at least be granted the opportunity to put his case, the court consider it. So to boot him out without so much as a court hearing was depriving him of his liberty. And the Home Secretary, I know he or she is elected to Parliament, appointed to the Cabinet, has the confidence of the Prime Minister and so on, is to be scrutinised by Parliament, but that doesn't mean that he or she can break the law in this regard. And another thing, how as a constitutional abstraction, is the Home Secretary, as an office holder rather than as an individual, sometimes the government has to pay compensation, and that's out of taxpayers' money. It's not the relevant minister is personally liable for it. Maybe you should think it'd be different. They would take their duties a great deal more seriously, but then again, who would go into politics for that with a case? Only wealthy people, but then they tend to be even more jealous and even more tight-fisted about their money than Joe Average. Anyway, so Dicey said that disputes about law are settled by the courts. It might seem to go without saying, but there we are. So the courts, they are there for judicial interpretation, statutory interpretation. That's a whole other lecture, really. What does the statute mean, and can we infer things from it? Can we read things into it? Aren't there between the lines? And we have to interpret this in the light of social reality. That's what they say in Spain, for example. So I know that the courts of England and Wales, they learn from other Commonwealth jurisdictions, occasionally from mainland Europe. Now, those are Roman law jurisdictions, but there's always been a dialogue between Roman law and common law. And since 1973, when the United Kingdom joined the European Union, the two somewhat converged because of the European Parliament, and as of January, perhaps have begun to diverge a little bit, but we shall see. It's an evolution. It's a work in progress. So law is always driving forward, sometimes going backwards, but it's ever evolving. And that's why you really got to keep up with it, see what statutes have been passed, what leading cases are, what the obiter dicta are, or more importantly, what the ratio decidendi are, the reasons for deciding. Obiter dicta being the other statements made when the judge was coming towards his or her summation, some other observations made. Anyway, so look at Heathrow, the third runway, this most vexatious issue. They've been humming and hawing about that for a quarter of a century. Is the third runway going to be constructed at Heathrow Airport? And a couple of months ago, there was the government was minded to do it. There was judicial review, and the court said you can't do it. However, the government could appeal that decision, could possibly overturn that decision, and could yet build it. They showed little inclination to do so at the moment. As you can imagine, they're more preoccupied with coronavirus. So just because the government does something, that does not automatically mean that it is legal. Now, when it comes to judicial review, the government wins about 75% of the time. Now, that's unsurprising. You would expect the government to act legally most of the time. Plus, they've got their in-house lawyers, Home Office barristers and so forth. The Attorney General is in the House of Lords usually. There's a Solicitor General, and they are invariably qualified either as solicitors or barristers. And the Lord Chancellor, until, say, 2005, was always a barrister, and saying, well, what is the law here? And looking it up in the statute book or LexisNexis in more recent generations. So the government is trying to keep within the law. It doesn't want to have its actions blocked by the courts. So the courts have been sometimes a thorn in the side of the government. The judiciary must be independent of the government and indeed the opposition. All right, they're not there to be oppositional, no judicial activism. They should be neutral on politics. They are upholding the law, popular, unpopular, and that's why it's important that they're not elected, because they don't care about that. They're not overly swayed by public opinion. People may fulminate, may curse them, but that's unimportant to them. They just do the right thing. They get on with it. They rise above it. Whereas politicians, they've got to win elections. They can't do things which are too unpopular. They've got to be short-termist, and courts are not like that. Because we don't just want them to be another bunch of politicians who are, pandering to the lowest common denominator. We want them to be actuated by higher motives and to be unfussed by passing fads. So anyway, Dicey said that rights were what formed the Constitution. It's not the Constitution which formed rights. Again, it's a contentious statement. So the Constitution of England and Wales, and subsequently the United Kingdom, grew out of the rights which already existed. Where do these rights come from? I mean, out of the Ark or what? I mean, what are rights? That's another jurisprudential debate. Are they things that are actually laws? Do they exist on a philosophical level, or are they simply assertions? What's my view? I suppose that they're laws, really. I could say that I have the right to £1 million house or something, but that's really just a desire on my part. There's no law to say that's true. It'd be difficult to construct a watertight philosophical argument for that. Anyway, so the Constitution, and what is the Constitution of the United Kingdom? It's very questionable. So people say it's Magna Carta, but of the 63 clauses thereof, only 3 are still extant on the statute book. Now, the others haven't been completely binned. They've often been reformulated, transposed into law, stripped of some of their content, because so much of Magna Carta is about property rights, inheritance, taxation, the rights of boroughs to send and receive goods. A lot of this is not relevant anymore. But there are some things which are key there, and actually very little of it was original to Magna Carta. That nobody would delay or deny or sell justice to anyone. Remember, trials need to be really reasonably swift. Justice delayed is justice denied. It's a well-known legal maxim. Contrast that with a Roman law country. I remember Raoul de Villepin, one of les Amis de Alsace-Lorraine, when he assassinated Jean Jaurès at the outbreak of the First World War. This man was charged with murder, and his trial didn't take place for 5 years. Okay, in England and Wales, if you're charged with murder, your trial would typically start within 6 months, because there's time to gather evidence. Trials mustn't be rushed. We must have fair trials, sufficient time for the defence to build their case. Well, I'm slightly jumping the gun on this. Anyway, Dicey, I don't completely agree with him. So Joseph Raz is an Israeli professor of law, and he's a famous thinker on this issue. So he studied at one of the universities in the state of Israel, later attended Balliol College, Oxford, where he sat at the feet of H.L.A. Hart, who died some years ago. He's buried in Wolvercote. Not such an astonishing headstone, but he's in good company. Wolvercote, just north of Oxford. Anyhow, so Raz, he laid out 8 principles of the rule of law, saying that these laws, that they must be clearly expressed, they must be openly accessible, so we can actually read what they are. They are in statute books, they're in LexisNexis and so on, they're law reports, so we can find out what it is. Because remember, the old maxim, ignorance of the law is no defence under law. I didn't know burglary was illegal. You got to let me off. Or I didn't know the speed limit on the motorway was 70. I thought it was 170 or something like that. I didn't know what the age of consent was or something like that. I didn't know I had to pay tax. No, this won't wash, and you can see why. Now, sometimes these might seem to be a bit onerous, especially if you just arrived from abroad. But there we go. What if you had no reasonable way of knowing if this was the case? Imagine you're a Japanese soldier, the Second World War has ended, and you're in the jungle of wherever it is, and you've not heard the war has ended, and then you kill someone who's a soldier of an enemy country, not realizing that there's no longer a state of war. Are you guilty of murder or not? A good question. Well, if you're really going to go by that law, you'd have to say you are, because even though you didn't know, it's up to you to make sure you're apprised of the law. Now, I think courts would be a little bit sensitive, might give you an absolute discharge, or this is why the Crown Prosecution Service would enter not a prosequi. Obviously, depending on which jurisdiction you're in, you may well not be in a common law country. If you're in the Far East, Malaysia would be a common law country, that they've got elements of Sharia. Now, let me see. So Raz said that laws must not be retroactive. there's that legal maxim that there can be no punishment without law. It was tried at Nuremberg. You're saying what we did was a crime. Can you point to me to the statute which says this is unlawful? There isn't any, therefore I'm not guilty. So even in the Napoleonic Court Code, the very first article says nothing in this code has a retroactivity. Is only prospective. It can only affect people from now on. All right. So laws must have a reasonable degree of continuity. They mustn't change on a daily basis. Therefore, otherwise people wouldn't know what the law is. So yes, new laws are always being passed. They're always being repealed. But how much is too much? Raz doesn't fill us in on this one. Like so many things, courts have to decide what's reasonable. What would the man on the Clapham omnibus believe? As in, what would the average person believe? And how do they decide that? I don't know. And courts often say, well, yes, there is an argument, we agree that up to the point, but only so far. There's a slippery slope. They've got to draw a line somewhere on the slippery slope. Do they always get it right? Probably not. But nevertheless, someone has to do it, and they draw their line. Anyway, so Raz goes on to say that there ought to be clear procedures for legislation. So we know that in the United Kingdom that things have to pass through the House of Commons thrice, 3 readings, House of Lords thrice, and then receive the royal assent. And for over 3 centuries, the monarch has always agreed to things and signed off on it. Queen Anne was the last person to simply exercise this royal veto. Like take George III, the India Bill saying, anyone who votes for this shall be my enemy for life. Nevertheless, he suffered his signature thereupon. And then you hear the golden words in Parliament, la reine le veut, as in the Queen wishes it. And then it is the law. They still say it in French. But the trouble about the UK Constitution is, what if when Charles inherits and he says, no, I'm not going to sign. Tough. There's no law saying I have to. Actually, it's a convention, not a law. What happens when push comes to shove? Now, that's one thing about the flexible UK Constitution, is it's dealt with these tricky situations before. Say the mental incapacity of George III, and they passed that Regency Act. But wait a second, that needs the royal assent as well. So he signs it, George III signed it, presumably. But if it was not compos mentis, does that have any legal validity? Somehow they thought it was. What if he refused to sign? I don't know. They haven't provided for every possible eventuality. They'd have to make it up as they go along. And this is one of the debilities of the UK Constitution, that it's so unclear, it's so flexible. Is that because it doesn't exist? And no, what statute actually says there's a constitution? There works of authority, Erskine May is part of it. Says who? Walter Bagehot's the English Constitution is part of it. No statute says that. This has just grown up. It's arbitrarily. We're meant to not be arbitrary. Anyway, I think there ought to be a UK Constitution Act saying these are the works of authority, a part of it, these are the statutes, a part of it, and then we'd actually know. Might not be as time consuming as everybody seems to assume. So HLA Hart, as in the mentor of Raz, says we ought to have a legal recognition. There's this belief in legal positivism. We need to know that something is a law, all right? We need to know that Parliament passes statutes at a lower level. Well, there's the Welsh Assembly, Northern Ireland Assembly, there's the Scots Parliament, there's the London Assembly, the various county councils passing bylaws to only affect their county. And indeed, sometimes Parliament confers certain authorities on executive figures like, say, the Foreign Secretary or the Education Secretary. So there's independence of the judiciary, part of the separation of powers. They're not to be strong-armed by the executive, can't be simply sacked because they make a decision which the executive finds inconvenient, nor can their salary be slashed on that basis. They are not to accept any inducement therefore they make their decision without fear, without favour, and they should be insulated from public opinion. They are not to be badmouthed by politicians. Now again, that's a convention, it's not a law. Take David Blunkett. He was Home Secretary around about 2004, and if the judiciary made a decision that he found uncongenial, he would go to the press and he would fulminate again about this judge as well as the decision. So it was highly unbecoming of a Home Secretary. Now, Tony Blair was Prime Minister at the time, a barrister who should not have tolerated this. It was deeply inappropriate it was just unseemly that he would be publicly undermining faith in the judiciary like this. The judiciary, they don't go on the media spouting these tirades against politicians. No, that would be deeply wrong. Anyway, so you've got to accept the independence of the judiciary with good grace. Or let's say the Mark Duggan case, this black man who was shot dead in London in 2011 by the police. They claimed they had intelligence he was going to kill someone. He turned out to be unarmed. Was he lawfully killed or not? It went before a jury, and the jury decided that he was lawfully killed. Now, that infuriated some people. There's some days of riots. But Diane Abbott, who'd been a main campaigner for him, who felt that he'd been murdered by the police, she accepted the verdict. Give her due. All right? She said, no, it would be wrong of a politician to simply say the courts are wrong. We don't do that, because we have to have independence of the judiciary. Even if she privately totally disagreed with the decision, she was not going to impugn the dignity of the court. They'd heard more about it than she had. They'd sat in judgment. They were not trying to be popular with a certain segment of the community, and she was. She has to seek re-election. These people don't. They're anonymous. I don't know who the jury are. Anyway, so they're not to be politically manipulated. So politicians ought to refrain from personal attacks on judges, or indeed publicly disagreeing with their decisions. Do judges get it wrong? Yeah, inevitably they do. To err is human, to forgive divine. So some of these decisions are always going to be contentious. Somebody's got to lose. In any case, criminal or civil, there's always a loser. As very to say, there's no justice in this country. Well, throw a hissy fit. If it was the other way, the other person would be saying the same. Anyway, so they are independent. They provide judicial review of government decisions. They check that nobody's acting ultra vires, as in beyond their authority. So your authority is limited to your department or whatever, or to try and adjudicate the boundary between a legislative authority and executive authority, or indeed judicial authority. Now that might be another flaw in the system, because they're self-regulating. So they ought to be impervious to public opinion. Reminds me of the old Latin tag, fiat justitia ruat caelum. Let justice be done, though the sky should fall. They should do this regardless of the repercussions, even if it will infuriate large swathes of the population, even if it will be wildly popular. They don't care. Supposing the most popular man in the realm, whoever that is, commits a crime, he must be found guilty. And he must be punished appropriately, not too much, not too little. Supposing the most detested person in the United Kingdom, I can't think who it was, suppose it was Jimmy Savile, were alive today, and supposing he was charged with shoplifting, and say, yeah, get him again, but he was not guilty, he should be acquitted. Or he was in prison for sex crimes against children, but he had a reasonable case that somehow been mistreated by a guard, he should win his case. Okay? Even if you absolutely revile him, we do justice to every individual. We're not just trying to be a lynch mob, or we're not just trying to let somebody off because he's popular. Anyway, so there must be natural justice, fair trials, okay? So there'll be a defense barrister as well as one for the prosecution, and time to prepare things, rules of evidence, disclosure of evidence. You can't be keeping things back. Now, the police, decades ago, they sometimes manipulated things. They discovered evidence which was likely to be useful to the defense, and they deliberately withheld it. No, you must disclose everything. So you can't spring ambushes on people in courts with bringing in a witness nobody anticipated. I'm afraid that's a bit Hollywood. That's one for the courtroom dramas. You have a right to silence. You don't have to plead. You're not obliged to testify. Take Jeremy Thorpe. You may have seen a very English scandal when he was charged with conspiracy to murder his former paramour, and he chose not to take the witness stand. His defence barrister, George Carman QC, said, no, you're not doing that, because if you're cross-examined by your defence barrister, you must also be cross-examined by the prosecution barrister. Or if the prosecution calls a witness, he or she can be cross-examined by them, but also be cross-examined by the other side, not to rush things, to give people a chance to speak in their own defence, and so forth. But the thing is, there's a summing up by the judge at the end. Now, the bench might try to nudge the jury this way or that way. That's their prerogative. Is that wrong? Possibly. they don't always get the result that they are leaning towards. And the judge doesn't make the decision. Obviously, in the Crown Court, he doesn't. It depends where we are. But there are other things magistrates do. That's the lower level of the criminal court, the lowest tier. So remember, the Lord Chancellery's been all three branches. That's long been sorted out because it was supposedly breaching Article 6 of the European Convention on Human Rights. Remember Lord Hubert's dictum in R and Sussex Justices ex parte McCarthy 1924, justice must not only be done, it must be manifestly and indubitably be seen to be done. Or remember Pinochet and Bow Street magistrates say, the former Chilean president, when one of the law lords, his wife was a member of Amnesty, which had been campaigning against Senator Pinochet Ugarte, so therefore he recused himself, which is to say he removed himself from the case, because even if he acted justly, there might be the suspicion that he didn't. He said, I approach these things by a judge, but we can't let there be any sense there was possible injustice. Caesar's wife must be above suspicion. So there must be also the appearance of justice. We mustn't undermine public confidence in the integrity of the system. So coming onto parliamentary